There are two approaches when dealing with the doctrine of the rule of law. One is the content-free and the other one is content-rich approach. This means that in the content-free approach, the emphasis is not on the substance of law, but the form and procedure of law. On the other hand, in the content-rich approach, the substance of law becomes important. According to Professor Dworkin, the content-free approach is flawed, and it is very limited because it is a rule book conception of the law. In the content-free approach, the law is looked at as a book of rules. The book even contains rules on how to change the rules. Professor Dworkin proposes a content-rich approach that he calls the rights-based conception of law. In this approach, the law is perceived to be constrained by rights that are granted to citizens by a higher constitution. Professor Dworkin states that the rulebook conception is a very narrow conception of the rule of law, as it does not state what the rules ought to be. Instead, it states what the rules are and how they are changed by other rules. He further highlights the differences between the rulebook conception and the rights-based conception of the rule of law. In the rulebook conception, there is only one dimension to the protection of rights. Thus, if the rule states that the government can exercise its power against the people or a group, then the protection of rights is failed in the single-dimension view. However, in the rights-based conception, there are three dimensions, and the government has to fail all three for the rights to be ignored. The first one is that the government might fail in delivering the scope of rights it had promised. The extent of freedom, as in the case of expression, becomes crucial when enforcing rights, especially enforcement of rights against the government itself. The second dimension is the failure to accurately enforce the rights. Here, the government is bound by the rights, and failure to follow them accurately is another failure on its part. The third dimension is that the government might fail in providing the protection of rights to its citizens in a fair and a just way. This may include neglecting a segment of the society or marginalized group when enforcing rights. Now let's look at the content-free approach. We will look at the thin definition of the rule of law as provided by Professor Raz. He states that the rule of law is a doctrine that deals with the degree of conformity. The closer we are to the ideal, the more we are upholding the rule of law. Furthermore, the doctrine represents a negative value. This means that the rule of law is designated to minimize the harm to human rights values in the law's pursuit of social goals. Finally, Professor Raz states that the rule of law should be used as a rule to conform to good laws, but the doctrine itself cannot become a goal in itself, because there is a danger that a lot of good social goals may be sacrificed in the name of rule of law. Professor Raz takes us away from the right-based conception and puts rights in direct competition with other social goals. You can argue that this is the case in most of the situations. For example, in pursuit of national security, the government might tend to violate the privacy rights of its citizens. According to Professor Raz, the privacy rights cannot be focus point here, because the social goal is to provide security to the citizens. This can also mean that if the parliament passes a law following the rules, it can ignore the rights of a minority group of the population. Again, the emphasis here is not on rights, but the rules. Let's look at Professor Craig, who himself believes in rights-based conception of the rule of law, but explains why some people think that we should keep away from rights-based conception. If rule of law is bound by the idea of good laws, then the rule of law will lose its independent function. He points out to the wealth of knowledge we have in regard to human rights. But he also makes it clear that mixing the knowledge with the doctrine of rule of law will make the doctrine itself useless. He also makes another interesting point, that we can always use the knowledge base of human rights and construct good arguments for the protection of rights. On the contrary, giving the rights the name of rule of law will add nothing to the discussion, because it will be like reaching a conclusion before presenting any arguments. As you can see, the content-rich approach suggested by Dr. Dworkin provides a stronger protection to rights, which means there are more protection of the right-based conception of the rule of law. This, however, takes us away from other doctrine of constitutional arrangement, and that is the sovereignty of the parliament. On the other hand, the content-free approach seems more practical and may be more acceptable to the executive branch. The approach suggests that there is no benefit in mixing the rights into the doctrine of rule of law, as the rule of law should only be used as a measure of conformity of laws to come to a conclusion of having good laws or bad laws.